Let me say. So with due consent of the other side, I'd like to mention item number 36. In this case,
Request of Mr.
H. Budagohai, Lordship. H. Budagohai
For
for S. Biswas claims.
for the petitioner matters can be adjourned to be listed after 6 weeks.
Me, please, Your Lordship. Lordship, with the consent of the other side, I would like to mention item number 21 and 22, Lordship. Lordship, my senior is suffering from retina
The request of Ms. So-and-so matters can be adjourned to be listed after 6 weeks.
May I please, Your Lordship, one read petition, Lordship, I have filed yesterday. I may be allowed to move on tomorrow, Lordship, one demolition matter, Lordship.
Today,
Yes, Lordship, but today, Lordship, there is a reference, Lordship.
okay, we don't want to move it today.
Obliged, Lordship.
Commentary list. Item 37, top of the list.
Lordship, that judgment relating to Somesh Tiwari, that your Lordship. There, this aspect was discussed, that section. Para 33.
Yeah.
Para 33 regarding that compulsory retirement, it has been discussed. Okay. 17.
Here also, it does not say anything on that.
That retrospective effect, this judgment is not on retrospective. It's about the rule making power that regarding that rule 27.
Rule 27 has been taken care of.
Yes,
That
Lord.
it can be passed.
Yes,
Therefore, I say, when you are saying about the CCS thing, it is not required. They
Yes,
have,
Lord.
it is intravirus. It
Yes,
can
Lord.
be done.
That has been upheld by this.
Yes.
What argument I have given, that has been annulled by this judgment.
Now, you said about the one has to go to the CCS.
Yes, Lordship,
That
that
is
was
not
my,
necessary.
no, this judgment has made it clear that Rule
It can be
27?
done under 27.
Yes, Lordship,
is
that can
okay.
be done.
But the question is whether it can be done retrospective.
The Lordship, that judgment that day I have given, that was having two parts. One is regarding the retrospective effect, and one, the compulsory retirement was upheld because that was also challenged. But retrospective effect was declared to be illegal.
No, it was declared to be illegal. Yes.
Second part.
You are saying about this.
Yes, Lord. Second part.
Given from judgment.
Yes, Lord.
Let us see which portion you are referring to.
Lordship, both the copies I have given that day by mistake. My office copy is also.
Portion.
Lordship, in page number 4, the order dated October 17, 1950, directed that the appellant be dismissed from service with effect from the date of his suspension. That is to say, from May 20, 1949. In substance, this order directed that 1, the appellant be dismissed, and 2, the dismissed do operate retrospectively as from May 20, 1949. Two parts of these composite orders are separable. First part of the order operates as dismissal of the appellant as from October 17, 1940. The invalidity of the second part of the order assumes this part of to be invalid, does not affect the first part of the order. Means that retrospective effect part was given away.
There is the finding. It cannot be given.
So they have not given the clear finding, but they have held it to be from the
Where is the-
1950.
See, you are to rely on law, wherein the law categorically say that you cannot be given a retrospective punishment.
So let it be an at 2, I will give specific judgment on it.
That is the what I am
Yes,
asking.
Lord. That specific judgment
I am not asking you anything else.
at 2, Lord.
Yes, normally compulsory retirement cannot be given.
Retrospective.
Because compulsory retirements, if we go as per the FRSR, you are to be issued a notice giving you 3 months or 1 month or 2. Correct. That is one. Secondly, there are compulsory retirements whereby every period, just for example, you have reached 50, 55, 58, there will be certain checking being made by the authority concerned, and they file, okay, you are a deadwood, so therefore you are out. But if it's a compulsory retirement, therefore the question is, what is a compulsory retirement? Compulsory retirement may be a punishment, but as held by this court, that it does not otherwise affects, or it is not much of a stigma which is attached there.
Yes.
That is why it is not said to be a dismissal. There are various judgments are given. Dismissal is given, termination is given. Termination is different from dismissal. Dismissal is different from compulsory retirement. So these are the things which are required to be looked into.
Lord, sir, at 2, I will give.
Because one thing one has to take note of, that this court, by the division bench held it, that the question of dismissal does not arise. So asking them to go ahead and to do it properly and give a lesser punishment. Isn't that the order which was passed by
Yes,
the
Lord.
division? So against that, what they did, they went for compulsory retirement and making it retrospective from that date.
Yes, sir.
So if it is retrospective from that date, can it be given in a case of compulsory retirement?
Yes.
If you cannot find it out on reopening on 7th, you can't find it. This is the question. This is the simple question which I have been asking you. Can you be done in this manner?
Lordship, I'll give specific judgment on that, that the deed cannot be given retrospectively.
When?
At, Lordship, on 7th, because I will have to find it out.
We have it on 9th, not 7th. Matter which the question which I heard Mr. S.N. Tamuli, the learned counsel for the petitioner, and Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents. The question which arises before this court in the present proceedings is as to whether a punishment of compulsory retirement, which is envisaged in terms with Rule 27
Yes.
of the CRPF
Rules.
rules 1955,
Yes.
55, 57,
55.
55.
1955.
Huh?
1955.
55 is the act.
CRPF rules 49. 49 is the act, 55 is the
55.
rules.
Permits imposition of a punishment of compulsory retirement with a retrospective effect. The counsel appearing on behalf of the petitioner seeks some accommodation to list this matter for further hearing on 9/1/2025 at the top of the list. This is the specific question which I am asking you. Okay?
For motion item 1,
That will your lordship. It's a contempt regarding non-compliance of order dated 11/12/2023 lordship. Impugned order is at page 27 lordship.
Okay, what is the direction given?
Direction, my lord,
Is that the case of the petitioner for what?
for issuance of drug license, my lord. Within a 45 days period was there, my lord.
Who is appearing for the respondent?
My lord, notice.
Health. Health is there. Why you have not taken any action pursuant to this order? You give a copy.
My lord,
I will have the.
Give a copy to him. You have extra copy.
my lord will serve.
Okay, give that. Give it to him.
I have not.
Don't
I
necessarily.
get it.
Give it to him. See,
My lord.
Mr. Gogoi, there you must have appeared, somebody has appeared. Ah, yeah, you have appeared. Why this has not been complied with?
I will have the.
Take your instructions. We have it on 6th.
Yes. Yes, sir.
6/1/2025. This court have requested the standing counsel of the health department, Mr. E. Gogoi, to obtain instructions as to whether the order dated 11/12/2023, asked in WPC number 1243 of 2023, had been complied with or not, and if so, why? The registry shall show the name of Mr. B. Gogoi in the cause list. The counsel for the petitioner is directed to serve an extra copy of the contempt petition to him during the course of the day.
item
Just
2,
obtain the instructions, and I've given enough time, if necessary, pass the order.
Deeply obliged.
Yes, Mr. Khatunia.
Yes, ma'am. It's a contempt petition, my lord, alleging non-compliance of order dated 2/8/2024.
Is there
Page 16, my lord, the operative portion. Paragraph 15.
PWD?
No, it's a BTC, my lord. BTC, my lord.
No BTC council.
No, my lord.
Okay. Now, Mr. Khatuniya, tell me,
Yes, my lord.
how do you gel? I may use the word gel. Both Tamsir Ali and the directions here. Give me a good idea. How? On one hand, Tamsir Ali says that they will conduct verifications, and after making verification, they will pay as per the
Roster, my lord.
List.
List.
and how, that is Tamsir Ali.
Yes, ma'am.
But how do you then direct within 4 months? Give me a good idea. How is it possible?
My lord,
If Tamsir Ali is
Tamsir,
used,
during that time, my lord, because when the judgment of Tamsir Ali was passed, my lord, during that time, my lord, there is a law, there is a number of contracts. my lord.
whatever may be, but how do you give a direction for both together?
But now the situation is different.
Tamsir Ali never says you make. Yes, Mr. Nayak. You are BTC.
Yes, Lord.
You just take the instructions in this matter. I'm just, although it's a contempt matter,
Lord.
I'm just asking you to obtain because I don't first issue notice. You just take instructions, what has happened out here, whether it has been complied with or not. But only one problem which I feel means with this judgment is, on one hand, the court says follow Tamsir Ali, and second says pay within 4 months. How is it possible?
That difficulty we are facing in so many judgments, Lordship. In
Isn't it
some cases, it is.
you can't have Tamsir Ali and both together. Because that means you are, on one hand, Tamsir Ali says that make this verification, and therefore your order could have been made that you conduct the verification within 4 months and pay as per Tamsir Ali. The order should be in that
In
manner.
the meantime, Lordship, we have already prepared consolidated list for all the departments, Lordship, and we are paying accordingly, Lordship.
No, therefore, that is the only way. When I pass an order, I pass an order that you make the verification within 2 months, 3 months, whatever it may be, and pay as per Tamsir Ali. Then it is okay, it gels. But if you are saying that you follow Tamsir Ali and pay within 4 months, it becomes very difficult.
Lordship observes that, Lordship, then it will be helpful to us.
No, it's okay. That I won't observe now in a contempt. You just take your instruction as to whether this order has been complied with or not. Just put your name up there. You just I got to Nishna Divo. The order dated 2/8/2024 passed in WPC number 3478/2022. We go to P9. The order. And we are having it on 6th. Just obtain that instruction.
Lordship.
And your name would be shown out there. Only instruction as to whether it has been complied with or not.
Obliged.
Item 3 and 4.
Wait, please, my lord.
Yes.
My
What
lord,
is
in-
this?
my lord, in both these items, both these cases, the petitioners had applied as bidders for the NIT of construction of Thai Museum at Heritage Site.
Then?
The bid was later on cancelled, my lord. The bid was later on cancelled, stating that the integrity which has to be maintained by the bidders was breached by both the petitioners. Here, my lord, the petitioner in item number 3 is the father of the petitioner in item number 4. The petitioner number in item number 3, the petitioner, my lord, he is an old aged fellow. Therefore, he had executed a power of attorney in favor of his son. His son had once applied on behalf of his father as his power of attorney holder and once on his own behalf. Thereafter, my lord, the only issue
You are
involved-
challenging the minutes of the meeting dated 19/4.
Yes, my lord.
What is this 19.4? Where do I find it?
My lord finds it at page number 178 is the type copy, my lord.
Time Museum. What is your name?
My lord,
Om Prakash
in this
Agarwal.
case, Om Prakash Agarwal, and in the next one, Mahesh Kumar Agarwal.
Both of you were bidders.
Both of us were bidders, my lord.
You are not in good terms.
We are in good terms, my lord. The
So-
father and son are the.
Is it collusive?
No, my lord.
Then you are in good terms, but staying together,
Staying together perhaps, my lord.
staying together, very well. Then
My lord, the only issue which was raised is that both have been represented by the same person, both the firms.
both the bids for 1/3 and 2/3 has been signed by the person Mahesh Kumar. All the personnel in this were in view of the above the committee. So you are against the cancellation, forfeiting of the
Forfeiture
bid
party,
security.
my lord. We ought to have been given a chance to be heard at least, even as per section 11 of the Procurement Act. It states at subsection 3, if I may read, without prejudice to the provisions of chapter 4 in case of any breach of the code of integrity by a bidder or prospective bidder as the case may be, the procuring entity, after giving a reasonable opportunity of being heard, may take appropriate measures, including exclusion of the bidder.
What is
from the
that? Give it to- So dispose it of. Take a decision.
Representation is also printing otherwise.
Let me have the instruction.
Take a call on that by you. I'm not asking, I'm not deciding anything. You give him an opportunity, he will submit a representation and go and decide.
Representation, my lord, is already pending.
Huh?
Representation, my lord, is
The
already
matter
pending.
has been pending from 410. Notice was issued. You were asked to obtain instruction. The matter came up
No,
last
my
time.
lord, notice was not issued, my lord.
No, notice was not issued. 410, the court had issued notice, directed.
Let it be tomorrow. Or at-
Why?
at
Why
two-
tomorrow?
Please.
No, only thing is what? I'm not passing any order. I'm not setting aside anything. Not to give effect to this decision without giving them an opportunity to hearing. Matter
So
over.
whether that part will be necessary or not, madam, because this is a tender process. There is no question of madam violation of Article 14 of. So we are satisfied that madam there is the integrity issue.
No, I'm
we
not,
have rejected-
I am nothing to do with the cancellation. Cancel has been cancelled. That you have taken a decision to cancel is okay. I'm not touching on that. What I'm touching only to the effect is that you want to forfeit it, but by giving him a hearing. That's all.
That should be, madam, otherwise in tender matters, madam, there is no such opportunity is given otherwise. Because if it is for.
Then why do you have this act?
My lord, section 11,
That's why it
subsection
it
3.
needs to be heard, madam, from our side also. It will be a precedent tomorrow, madam. In every case, madam, where there is a forfeiture, we'll have to go for, madam. If somebody has misrepresented, madam, knowing fully well that, madam, he is the father and son. Of course, there is a question of giving, madam, whether so-called notice can, madam.
Let us see the tender condition.
My lord, forfeiture.
No, not for, yes, forfeiture.
Forfeiture, my lord, finds at clause 16.6. Those are the only grounds in the tender condition.
16 point.
6, my lord, that is at page 50. Yes, page 50 of writ petition 5195.
Where?
My lord, 16.6, the bid security may be forfeited if the bidder withdraws the bid after the bid opening during the period of bid validity. If the bidder does not accept the correction of the bid price pursuant to clause 27, or in case of a successful bidder, if the bidder falls within the specified time limit to fails within the specified time limit to sign the agreement.
Where is the integrity pact?
My lord.
Signing of the integrity pact.
Yes, that is it.
And why not, Mr. Biugoy? Why not we permit him to take action in terms with, clause 38?
That's whether it will be applicable in the presentation or not.
This is your tender document.
Short, let me not-
No, isn't this a tender document? Isn't this a tender document?
Yes.
Now kindly come to 38, page 58.
Cost 37, madam.
38. Let him file an appeal. What is there remain? Why should this court look into all these things? To decide. Bidder who seek to appeal against any decision, action or omission regarding this particular procurement may do so as per section 38 of the Procurement Act and the rules. The first appellate authority is this.
Alternative remedy is there, on deadline, lordship.
That is what I am saying. That is
Well,
what
lordship indicate this clause, madam, then,
here it is there, 38.
yes, yes.
You go there. I think that is a better option.
My lord, the representation dated 8/7/24 is already pending.
Whatever may be, I'm giving you the time of
Very good.
filing an appeal within 15 days. File an appeal. And thereupon they will take a decision. Isn't it? On receipt of the appeal and under certain affording an opportunity of so and so, the officer whom appeal is filed shall deal expeditiously and within 30 days. So as per 38(3), he has to decide within 30 days. So nothing remains.
Well,
Leho. Heard Mr. N. Chaudhary, the learned counsel, appearing on behalf of both the petitioners. Appearing on behalf of the petitioners in both the writ petitions. Mr. B. Gogoi appears on behalf of the PWD,
PWD and finance, all the
Huh?
respondents.
appearing on behalf of all the respondents.
4 and 5. One is revenue, madam. Why? Other is not necessary.
Mr. A. Bhattacharjee appears for the revenue department. Mr. B. Gogoi appears for the, what is this?
PWD and finance, madam.
What is this department?
PWD buildings.
Appears on behalf of the PWD building. And anybody else? Nobody,
And finance, madam.
as well as for the finance department. Let him be there. One more finance. Why you are taking everything? Huh? And Mr. P. Nayak appears on behalf of the finance department. Both the appeals, both the petitions have been filed assailing the minutes of the technical bid evaluation committee dated
19/4/2000.
19/4/2024, whereby the bid evaluation committee, whereby whereby the whereby the respondent number 4, that is the technical bid evaluation committee, had cancelled the tender process and also decided to forfeit the bid security so submitted by the petitioners, by the petitioner in the petitioner in both the writ petitions. Full stop. Briefly stated, the facts which arise for consideration is that the chief engineer PWD building had issued a press notice dated 14/2/2024 inviting fresh bids for the work of construction of Thai museum at heritage site of Habung in Dhemaji district under the PWD global head for the year 2023-24. Subsequent thereto, a detailed notice inviting tender dated 19/2/2024 was issued. Full stop. The petitioners in both the writ petitions, the petitioner in both the writ petitions, admittedly are related in as much as the petitioner in WPC number 5195/2024 is the father of the petitioner in WPC number 4658/2024. Post. Both the petitioners thereupon submitted the bids. Post. Upon submission of the bid, a technical evaluation was carried out whereby the technical evaluation committee was of the opinion that both the petitioners and the petitioners in both the writ petitions had committed breach of the code of integrity and was found to be in conflict of interest as per the Assam Public Procurement Rules 2020, and more particularly clauses 6(3) C, D, E, and F. Accordingly, the Technical Evaluation Committee, bid committee, that is the respondent number 4 in both the writ petition, decided to cancel the tender process and forfeit the bid security of both of the petitioners in both the writ petitions. It is under such circumstances the instant writ petition was filed. It is relevant to take note of that this court, by an order dated 13/9/2024, and it is relevant to take note of that on 4/10/2024, that the matters that both the writ petitions it is relevant to take note of that WPC number 4658/2024 came up before this court on 13/9/2024, and WPC number 5195/2024 came up before this court on 4/10/2024. I'll take it as your submission about it. This court, upon hearing the matter, Mr. N. Chaudhary, during the course of the hearing, has drawn the attention of this court to clause 38 of the instruction to the bidders, which contains an appellate provision against any decision, action, or omission regarding the procurement sought to be made by way of the tender in question. The learned counsel therefore submits that, taking into account that certain facts needs to be adjudicated upon factually, it would be well served upon the petitioner to approach the appellate authority as mentioned in clause 38 of the instruction to the bidders. He also submitted that the petitioners had also submitted the representations earlier, which have not been taken into consideration. Mr. B. Gogoi, the learned counsel appearing on behalf of the PWD department had submitted that he has no objection in the petitioner approaching the appellate authority as mentioned in clause 38 of the instruction to the bidders. Taking into account the above, this court therefore disposes of both the writ petitions with the following observations and directions. Number one, the instant writ petition stands closed on the ground of availability of an alternative and efficacious remedy, as would appear from a perusal of clause 38 of the instruction to the bidders read with section 38 na, of the Assam Public Procurement Act 2017. Number two, the petitioner in both the writ petitions are given the liberty to avail the appellate provision under section clause 38 of the instruction to the bidders within 15 days from the date of the instant order. Number three, the appellate authority shall, upon filing of such appeals, shall decide the same by following the mandate of section 38, more particularly 38.2 and 38.3 of the Assam Public Procurement Act 2017. With the above, the petition stands.
Regarding my submission, at that my lord, since my lord, there is already alternative remedy prescribed with.
This is why I'm dismissing. I said that, no, I'm
No,
not
my
entertaining
part.
because of. No, I'm saying that you have no objection if he goes there. That is what I'm saying.
Only thing, my lord, this will not know, this order will have no bearing on the main tender process. My lord. One line, my lord.
It is further observed that the grievance of the petitioner. Now, before parting with the record, this court further observes that taking into account the source of the case of the petitioner, the grievance so entertained herein is only in respect to forfeiture of the security deposit. This court have not commented anything in respect to initiation of fresh tender process in terms with the order passed by the.
No, my lord, probably other tender,
Fresh,
there has been rejected.
No. You have gone for cancel fresh tender.
Fresh tender has been issued by the.
Issued, na? So nothing even. You see
That's
this.
not.
That is not.
Page 180.
Not-
Not necessary. Yes, in view of the above, the committee decided to cancel the
Not-
tender.
not-
So nothing even. Should I
That's what my-
maintain?
Hey, let it be made, my lord, she will already given the liberty go for fresh. my lord.
So that I've given. Should I mention this before parting with the record? Not necessary.
No, it may be there, madam. It will clarify it. Let it be there, let it be there, madam. My prayer, it has been.
As clear too, before parting with the record, this court finds it relevant to clarify
Yes.
that the grievance of the petitioner which have been entertained in the instant proceeding is only in respect to the forfeiture of the security, bid security. The same has no connection with the initiation of fresh tender process.
Item 5,
Yes, what it is?
My lord,
Pursuant to the quotation dated 12/5/2016, my lord, the petitioner was supplied the relief materials, my lord, which was duly received by the concerned authority.
You want money?
Yes, my lord.
Money not paid.
Death notice book.
Okay, if you notice making it returnable by by 12th of February 2025. Miss Yuda, the learned additional senior government advocate, accepts notice on behalf of the respondent number 1, 4, and 5. Mr. A. Bhattaji appears on behalf of the respondent number 2 and 3. Taking into account that all the respondents are duly represented, extra copies of the petition will be served upon the respective counsel during the course of the day. The petitioner hearing is aggrieved on account of the non-payment of an amount of rupees 24,96,753.78 on account of certain works,
No, no, my lord. Supply of relief materials.
supply of non-payment of an amount of rupees on account to which the petitioner is entitled to on account of supply of certain relief material. The respondents are directed to bring on record their stand by filing the affidavit on the next.
Much of it.
Item 6,
Well, 6 is also setting.
Same.
Set. Much of it.
Amount will be different.
What amount will be? In here, my lord, the 3,77,936. Much of it.
7,
Yes, what is this?
Hello, it is regarding the payment and the cancellation.
Where
of-
is the GMC council? He was very much supposed as to why payment of the work done by the petitioner should not be made with interest on due measurement of the admitted claim.
These are the, my lord, these covered cases already been disposed of, various cases. And the order already I have annexed here. Page 18 annexed.
Mr. Sarma, where is your prayer? What is your prayer?
Regarding my lord, measurement and payment of my work done.
Not be made with interest on year. How much is the amount?
That much total, my lord, the work done.
Where is the GMC? Mr. Nayak was very much here, huh? Okay, issue notice making it returnable on where? Not clear.
Matter of the covered cases, my lord, like the page 18 annexer H. Similar cases are disposed of.
What work did you do?
My lord,
I disposed of some matters like this.
yes,
It was terminated and all.
yes.
And there was a direction that they are measuring. And
Yes,
Mr. He was there. Where's my order?
Yes, that one of that order is annexer H, my lord, page 18.
Well, we heard Mr. J. Sharma, the learned counsel, issue notice making it returnable on 14th of February 2025. Mr. P. Nayak appears on behalf of the respondent numbers 1, 2, and 3 and accepts notice. Extra copies of the petition be served upon him during the course of the day. the petitioner herein has claimed that he has carried out certain works. Work for what?
My lord,
Work of
I
cleaning
prepared-
and desilting of the river Bahini. And thereupon, thereupon is entitled to certain amount which the respondents have not made any payment. So it is under such circumstances, the petitioner has approached this court. The respondents shall bring on record their stand by filing the affidavit.
Item 8.
Same, my lord. 7, 8, 9, 10. 7, 8, 9, 10.
Mr. Nayak, I put your names out there in all these matters. But you see, one matter, I disposed of Mr. Esbora was there, similar matter. I disposed it of. They say that we have made some measurement at that point of time.
In some cases, we have some measurement, but not in all the cases.
Not, and there was a direction as per the measurement, you make the payment. So that direction is there. But here I'm issuing notice on making it returnable on 12/2/2025.
My lord, it could have been disposed of, my lord, by that direction, my lord, similar direction.
But you have not got that order, no?
But
11.
But the other direction is different. There first, what
Here
had
also.
happened when the matter came up before me, I asked Mr. Bora to find out what is it. That was on Monday. On Friday, he came up with the observation that we have made certain measurements at that point of time, and accordingly, on the basis of that, directed them to pay, and they said that they are going to pay within 3 months or something. That was the direction. You have failed, can't help it.
Lordship will take up this matter on 12th, I mean, in February.
Huh?
But already passed notice, issued notice.
We should.
Lordship.
I made it on 12 to
Yes, Lord.
2012. Or 14 to.
14th.
You're lucky.
11.
Yes.
That resolution.
So there is an IF for implement of parties as a response number 3. That is the Registrar General of Guwahati High Court.
Why?
In respect of writ petition, my lord 6057.
What is wrong? What is your writ petition for?
My lord, my writ petition, my lord. May I read the synopsis of my writ petition, my lord?
Huh?
Synopsis I want to read, my lord.
What are you challenging? Considering the stated and so,
he's praying for.
cannot be issued for early disposal of CR case number AR which is pending before the. Why are you making the Registrar General?
This court directed by the order dated, my lord. 2011-24 to make the party register general. Initially, I was not made the party.
Why the matter has not been disposed of 2013?
My lord, accused did not appear. Accused appeared and thereafter absent, remained absent.
Absconded.
Not absconded. He has taken steps, but as it appears from the record.
You are the?
Petitioner, my lord.
That I know. There, complainant. Then?
He wants expeditious trial, my lord.
Then why are you not filing for 482? Why are we doing all this 226 business out here? Huh?
One of the honorable court was directed to me make the party.
No, first of all, can this court issue a writ upon that officer? Can I ask the Registrar General? No, tell me, let me also be knowledgeable. Can I ask the Registrar General to instruct a particular court? Registrar General acts an administrative authority to direct him so that he directs the court that you kindly finish up the matter. Can I do that? No.
Better maybe password for timing. My senior will appear.
Who is your senior?
He is in Lakes on court number 1.
We'll have it. I think better you withdraw a file of 482. 482 say that there is a delay in disposal, that that provision is there, not 300. What is that provision? 303 or 330 or whatever maybe. There was a provision in the CRPC, na? where it requires an urgent disposal on a, once the trial starts, but trial has not started.
That part actually I am not properly aware, madam.
Yeah.
Possible timing, madam, after some.
Time being, this is a case for dismissal right away. Get hold of your senior by 12.
For admission item 12.
Yes, madam. How a patta lane can be made khas lane?
My lord, may I pray some time, my lord?
Huh?
May I pray for some time, my lord, to get that instruction, my lord? Though I have seen the letter is sent from our office, my lord, we have not received instruction. May I pray, my lord, in the first week of January or my lord, second week?
First week?
Second week of January.
Third. 3rd of January is the first week.
But if your lordship pleases, then my lord, okay, but
Third.
even then it would be, I'll be,
Get your instructions. This was why, how you convert a road, make it a road.
fifth, maybe on fifth, my lord.
5th is Sunday.
Sorry, my lord, I'm following this.
And to come.
My lord.
List this matter on 10/1/2025. Pusto. Ms. Yudas, the learned additional senior government advocate, shall obtain the instructions as sought for by this court in the order dated 4/3/2024 without fail.
Lordship, lordship.
13.
Please, lordship. Lordship, kindly pass about a matter for time being. My senior is a like.
There's no time being business out here. You don't want to do it, don't do it. We'll have it after vacations.
No, saying instruction. Sometime.
Huh? Okay, leave the matter after vacations.
14.
Begging your pardon, my lord, there was a direction to collect the judgment you have passed.
Where is a fresh electrical accident that has been brought on record and so and so. GK also submits that he would not like to take instruction. Yes, what else?
I got one negative regarding contributory negligence to coordinate bench passed that. Regarding the contributory negligence, lordship, the coordinate bench, your lordship passed an order that deferred the opinion that if the both parties are liable, lordship, it is a matter of dispute, lordship, and directed to go to the civil courts.
Where?
Yes,
Which court passed? But I have passed another order. I'll follow my order. Where's my order?
My lord, I am not able to getting it.
Ah,
After-
not this one.
after several
Oh, this order, I already held it to be for you.
searching,
I categorically held it very clearly, without any doubt, saying that here it does not say contributory negligence or total negligence. It says negligence. So negligence may include many aspects. So under such circumstances, this is a welfare measure only for the purpose of giving, what do you call? Certain interim compensation. This is not for future. There might be. But if you are not able to get it, what to do? I can't help you. Hello, where did you find it? It is not so easy to get judgments like this. You find it, then we'll have it. When?
my lord, after searching your name, that always come with MSCT contributory, not electricity contributory negligence.
Huh?
Your judgment always come on contributory negligence that are related to MSCT, not electricity.
No, here I held it. That first, this is a welfare measure. This is done under 57. This is done under the 57 of the Electricity Act. It is a welfare measure. They are not going to pay you the entire amount which you are entitled to. What they are paying you is a solace for the time being, that you are given an ex gratia. This is like an ex gratia which is being given.
Yes, ma'am.
So therefore, whether there was a contributory negligence, because here regulation 5 only says about negligence. So negligence doesn't say total negligence.
Yes, sir.
It says negligence, which means even a contributory negligence is also a negligence. So under such circumstances, here you may be entitled to 4 lakhs, but you may not be entitled to further amounts as per 9.
My lord,
This is what I've held it. But if you don't get it, why should I? I'm not going to help people nowadays. Find it out. Ask Mr. B. Chaudhary, there was another counsel, na? I'm giving you the name of the respondent counsel.
all right, sir.
B. Chaudhary, B. Dot CHOW, not the U one, the W one.
All right, sir.
List this matter again on 8th of January 2025 for further hearing. I can find it out. Why should I?
All right, sir.
You have to toil somehow.
15,
Yes, what are the source? What is this?
Lordship, today we have filed our affidavit.
You filed your
Yes,
affidavit.
Lordship, in item 15, 16, 17, 18, 19, and 20.
You filed affidavits. All these affidavits. Oh, Mr. Jain, your petition starts with bigger cause title than here. First of all, why should we at all entertain your petition?
Interest,
No, no, no. Not a single document also.
my lord, in the,
Not a single document also.
the affidavit filed by the respondent.
Forget about the affidavit. We are not going to look into the affidavit.
Yeah, my
But
lord,
first
only
is,
10,000
where is one single, only a work order? Have you completed the work?
Yes, my lord, as per the affidavit filed by the respondent, my lord, only an amount of rupees 10,393 is due. In the meantime, my lord, the payment has been made, my lord. So, my
So,
lord,
withdraw.
I have to take instruction, my lord, in the next day, my lord, I have to taken today, my lord, itself, my lord.
The council appearing on behalf of the Water Resource Department has submitted that affidavits have been filed. Affidavit has been filed in the instant matter. Mr. D.K. Jain, the learned counsel, appearing on behalf of the petitioner, seeks some time to obtain instructions. This matter on 22/1/2025. All the matters are same, na?
Yes, sir. Lordship.
All separate orders first. Water resource. Everywhere affidavit file. You should not. You should have taken the ground that he is not entitled to.
I have
This is not the
mentioned-
manner in which you file a petition. Only a work order is given. Means no completion certificate.
Nothing has been,
We are here out here as a fact finding inquiry.
no, my lord, the order was, work order was genuine, my lord.
Work order will enough. Does work order show that you have completed? Tell me. Then. Okay, next.
Right, sir.
23,
Yes,
Right.
Mr. Ganguly, you are not appearing in this matter.
My lord, this case, my lord, the orders of the recovery officer were.
What is this matter? Considering the fact that hereby for the operation of the impugn orders dated so and so shall remain stayed.
I pray for a week's time to file the rejoinder. The rejoinder is ready, my lord. I pray for a week's time. Lordship may take it up immediately after the vacation, my lord.
Okay, there's an interim order.
Yes, there's an interim order.
What is the matter about?
Recovery officer of the DRT, my lord, issued 2 orders, my lord, in which warrant of arrest was also issued, and my lord, the direction was given to cancel the mutation in my name. My lord, my full submission remains that, my lord, these orders are beyond the jurisdiction of the recovery officer. He could not have issued those orders. He may issue these orders in accordance with the provisions of the RDB Act and the second schedule of the Income Tax Act. Those are there. You know, this matter requires certain deliberation, my lord, which you may kindly consider.
But you are not appearing. Yes, Mr. Batra. You are nowhere to be seen when the matter is called. Yes, what do you have to say? He wants to file a reply.
They could have, approached the appellate authority, my lord. The remedy is available, my lord.
Normally, this type of submission is also be given by Mr. A. Ganguly when he's on this side. Huh? Now what to do? Can you approve it and reprove it at the same time types?
No, not in the same matter, but in different.
Not in
matter,
the same court. Okay, Mr. A. Ganguly appearing on behalf of the petitioner seeks some accommodation for filing a reply to the affidavit in opposition filed by the respondent number 2. To stop. Mr. R. K. Batra appearing on behalf of the respondent number 2 expresses urgency and further further questions the maintainability of the petition on the ground of availability of the alternative remedy. To stop. Taking into account the above, list this matter again on 28/1/2025. In the meantime, the reply be filed by the petitioner. The interim order passed earlier shall continue till the next date.
Can it be on 29/1?
Absolutely no. This is for final disposal.
Hello.
That is, I am fixing on 28.
24,
So the interim orders may continue.
I said that.
Good.
Oh. SS Roy, have you filed the affidavit? Mr. SS Roy appearing on behalf of the respondent submits that the affidavit has been duly filed. However, the same is not on record. List this matter on 8th of January 2024. 5. Petitioner would be at liberty to file any reply in the meantime.
25,
Please, Your Lordship. My lord, here the petitioner is a contractor, first class contractor.
What do you want? Money?
But I have been provided PSO in the Karbi Anglong area, but I am doing work all over Assam. I sought for extension of the PSO for other areas.
You
Now
want what?
they-
Money? For PSO?
PSO, ma'am. And they are providing me, my lord, at page 60, they are providing me in the Karbi Anglong area, but I am doing work in the whole over Assam. Now they are saying that the threat perception as regards the other areas, they are yet to receive it. They have not made.
Why you're not filing? You have filed affidavit?
Affidavit. Para 12, they have said, madam, para 12. In their affidavit, the threat assessment report has been called from the DCP Guwahati, which is yet to be received.
It is an application to the.
That is provided, madam.
So with effect on.
They have provided in Karbi Anglong. My prayer is for,
So just outside the vicinity of Karbi Anglong, no person will come.
My lord,
What is the,
Yes, yes.
what is the basis? Okay, I understand.
my lord,
Tomorrow he is going to Delhi, he may not be entitled to.
Fine.
But how do you distinguish that only in the district of Karbi Anglong he has a threat, but just outside, if he just crosses Manjatini Ali, he won't? Tell me, give me a good reason for that.
my lord, in that paragraph itself, my lord, we have mentioned that now we have called for the report from DCP, my lord, that is yet to be received. May I pray to fix the matter, my lord, after.
See, for giving these PSOs, you have the threat perception done by various authorities. Now,
Lord,
have you brought on record that document?
documents we have not
See,
annexed.
you cannot give
That-
like this. A third threat perception, if he's asking for all over Assam,
Well-
that has to be a document, means it goes, there's a procedure, you have a guideline.
Well-
Mr. BJ Talukdar was appearing in many
My-
of the
Mr.
matters here.
Deepak also appearing in some cases, my lord.
So
regarding
there
PSO,
he has brought in that how it is to be given, who is first going to look into one, then thereafter first it will be taken from that circle inspector and then it will go to the DCP or SP. SP will give it to another person. Last is some board, there is a board. That board has to give. Where is this?
My lord, may I pray for some more time so that my lord, again, my lord, in
This is
that.
a matter
paragraph,
of person's life and death.
Lordship. But report has been, my lord, again sought for from DCP, my lord. We are yet to receive it. So may I pray for after 4 weeks, my lord, maybe fix this matter, my lord. So
Okay,
that
Ms. Yudas, the learned additional senior government advocate submits that she would like to take further instruction in the matter. Okay. Is this matter on 22nd of January 2025. In the meantime, a further additional affidavit be filed, bringing on record the further inquiries so conducted in the meantime.
supplementary item 38,
Where is this? This is the matter of the vacation.
Pending item 11.
Yes, what is this? What type of case you have filed?
My lord, I have filed,
You want a writ to be issued against the court?
yes,
Is it
it's the
possible?
order of the court.
Is
because-
it possible to issue a writ to a court? Tell me, give me a good reason. Let me also know that the judgment of the Supreme Court in 1954, a constitution bench, the judgment of the Supreme Court in 2004, 14 have all been overruled recently, which has not even come in live law. Tell me. In fact, 2 days back also the Supreme Court has made that. So should we tell the Supreme Court that they have made a wrong? Should ask you about this thing. How can you ask a writ against a court?
My lord, circular,
Withdraw. File 482 if you want anything to do. Don't issue a 226. Mr. So I and don't make all these things. You have to point it out there that this matter is getting delayed. File an application there that the matter has been getting delayed, and as such, kindly take up. If the court passes an order, no, then you come in revision under 480. This is how you do it. The counsel appearing on behalf of the petitioner submits that the petitioner, that taking into account that a writ is not maintainable against the court, he would not like to press a writ proceedings under Article 226 of the Constitution is not maintainable against the court, against the judicial court, a court. He would not like to press the instant writ petition. He further submits that he will take appropriate steps before the court, before the court of which court?
it's my lord, judicial magistrate, first class,
Before-
Kamrup Petro.
Before the judicial magistrate first class Kamrup Petro in connection with CR case number 1711/2013, and if so aggrieved, would prefer appropriate application before the High Court in exercising its inherent approach, and if so aggrieved, shall appropriately approach this court exercising in exercise of the powers under what is this? 482 has become now what?
500,
583,
523,
520,
528, 528.
528 of the BNL SS.
File name.
I closed.
Orders item 26.
Please, Your Lordship. Your Lordship, in this matter, we will file an additional affidavit, Your Lordship, and we will file by tomorrow. So let this matter be taken up after vacation.
Ms. So-and-so appearing on behalf of the petitioner submits that an additional affidavit would be filed in this matter and therefore seeks for some accommodation. Okay, list the matter after the vacations. In the meantime, the petitioner would be at liberty to file the reply. Additional affidavit.
JP obliged.
27.
This matter, Lordship, pleadings complete, and the petitioner's residence and the allotted land for Hajj committee, there is a.
Service complete?
Yes,
Why the matter has come up? Service as regards steps. Service is complete.
Previous occasion, the petitioner were to file their response, they have already filed.
we have filed.
So
Is the
maybe-
matter of taking into account that the service is complete, is the matter for admission after the winter vacations.
Obliged.
Okay.
Yes, what has happened?
Please, Your Lordship.
Dismissed for default.
Default in not-
Why? How can it-
On that eventful day, Your Lordship,
In the morning, the matter was mentioned for the adjournment.
Who
Yes,
mentioned?
I have mentioned, Your Lordship.
Then what happened? You were
Then-
then not there.
Oh, yeah. Later
Huh?
on, I have informed the conducting council that court has not allowed the prayer for adjournment.
And
And then he was busy in family court for some hearing in interim prayer. So he was unable to come at time. So that was the reason. I am, it was in paragraph 3 and paragraph 4 में payroll.
now the question says, how do you let this matter be listed before Justice Jothan Kumar? Because what he has said that the above shows that there are disputed questions of facts. If these are there, how do I restore it? Although he has done it under non-prosecution, but on the other hand, it says that disputed questions of facts.
It may be decided on prosecution.
So let the matter be listed before here. So taking into account, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Good stop. The instant application is an application seeking restoration of the petition being WPC number 3413/2018, which was dismissed for non-prosecution on 22/10/2024. Be that as it may, it is seen that this court by the said order had also opined, the coordinate bench of this court had also opined that there are disputed questions of facts. So under such circumstances, it would be proper that the matter be listed before the appropriate court, bracket there, appropriate court, who had passed the order dated 22/10/2024. Before the appropriate court, before the appropriate court,
On reopening, Your Lordship. On reopening.
immediately after
Immediately.
on reopening.
Obliged.
Item 29 to 31.
Order has already been complied. Payment has been made.
Huh?
Order has already been complied, my.
Complied.
Fine.
See, things happen like this only. The above contempt applications have been filed alleging willful and deliberate violation to the orders dated. These are different orders,
On same day, my lord.
different orders
Lordship.
dated 21/7/2023 in WPC number. WPC number. Which are the different WPC numbers? All are same date.
Same date, my. Three different date petition.
Huh? WPC number 18 silent, huh? So and so. Mr. So-and-so appearing on behalf of the contempt petitioner submitted that all the orders have been duly, all the orders passed by this court have been duly complied with in the three writ petitions. Also, taking into account the above, the contempt proceedings in the instant three contempt, the contempt proceedings in the instant three, contempt proceedings in the present matters stands drops. Stands drops.
Obliged.
Item 32.
What is this? Order 6/13.
Application is for correcting typographical mistakes. Lordship, the application is for correcting typographical mistakes in the cause title, Lordship. Two of the petitioners' names.
What are the changes you want?
Lordship, I have mentioned in para 6 of my application. Lordship, the name has been given as Biren Singh Tiso, but it should have been Biren Singh Teron, Lordship. And then should have been son of Kolom Singh Teron, Lordship.
So petition number 13 and petition number 46.
46.
Names are different.
Names are different. The 13, the
Because
names,
the
is-
wife was-
names are different. 46, the husband's name is different, Lordship.
Yes, any objection? The instant application has been filed seeking amendment to the writ petition. Only to the effect that there are certain typographical errors in mentioning the name of the petitioner number 13. And the name of the son and the name of his father and the name of the father of the petitioner number 13. In addition to that, amendment has been sought to make correction as regards the name of the
Husband.
as regards the wife of as regards the name of the
Husband of the
wife of petitioner number 46.
husband.
These amendments have been categorically shown in paragraph number 6 of the said application. Full stop. This court have also heard the learned counsels appearing on behalf of the respondent numbers
3, 4, and 6. KAC.
on behalf of the Union of India. Anybody? S. Burua was here, no, today? S. Burua for the Union of India. Mr. So-and-so
R.S.
for the
Rama.
KAC. Mr. C. Burua was there today. I saw him. C. Burua. C. Burua for NHIDCL. And have the said officer and the said respondent councils objected no objection, made no objections to the said amendments. Taking into account the above, the amendment so set forth in paragraph number 6 of the application is allowed. The petitioner is accordingly directed to file a fresh amended writ petition along with the which shall include the enclosures and along with the enclosures within on or before 8th of January and file an amended writ petition before the registry of this court on or before 8th of January 2025. Full stop. Extra copies of the amended writ petition be served upon the responding councils.
Lordship, I have another prayer, Lordship, with the main petition, Lordship. I had filed Annexure 9, which was a table of all the petitioners along with their details of the land, Lordship. The same mistake has been also occurred there. I was thinking that I would file an additional petition, Lordship, additional affidavit with regard to Annexure 9, Lordship.
File it, who has asked you not to file it? In the additional affidavit, you say the reason why you do it. I stands closed. Application number 20.
$33.
What is this?
May I please, Lordship?
Yes,
Once your Lordship restored the matter, my lord, again same mistake, my lord, name was not shown. Therefore, again, my lord, dismissed for default.
what is this section 5?
My lord, limitation, my lord, there is a
Limitation applies. Where is the dismissal order?
my lord, dismissal order I have annexed 1, my lord, annexure 1, page 11, relevant portion. my
Where is the IA for restoration?
Restoration miscase, my lord, 86.
86. Where is the order?
My lord, this, my lord, dismiss for default order, my lord, relevant portion, page 11.
Page
page 11.
Dismissed for non-prosecution by the several two miscellaneous applications, so one for recalling the order. Why haven't you appeared?
Kindly, Lordship, may look page 12.
Yes.
Here in this case, the last one, my lord, call list I have annexed. My lord,
What's
here
the name of the party? Senti.
serial number 8, my lord,
What is your writ petition for?
contractors bill.
Huh?
Contractors bill, my. Payment of contractors bill.
They file affidavit.
They have not filed that.
Hello. They'll come after vacations. First of all, what is this limitation for application being filed? Is it heard of?
My lord,
You are such an astute advocate, you know everything about law and you say, bring the limitation act out here.
some court, my lord, for abandoned petition, my lord,
Are you saying some court doesn't know that in a writ, the limitation act doesn't apply? Are you saying that? These are all recorded. Either this time, have you read the judgment of the INRI section 6A? You read that? You do a lot of matters pertaining to those, no? Foreigner tribunal. You do a lot of matters.
Yes.
And you have not read the judgment. This section, what, how does they say, what did the Constitution bench say about Limitation Act? It is all along. It's from 1951 only, there are judgments. Limitation Act does not apply to writ proceedings. Because writ proceedings is not a court within the meaning of the limitation.
34 and 35.
Take these matters after vacations. I too. 33. 33 after vacations.
And if possible, my lord, any date may be mentioned. my lord. Oblige.
Yes, what is this?
And I'm appealing for item number 35, which is already fixed on 5th February, I think, Madam. And this has come because item number 34, somebody has filed an I.
Who has filed?
Petitioner have filed, my lord, then the petitioner in 35 must have filed.
34.
34 has filed, my lord. But my lord, in this matter, GMC is required. Allegation is against the.
Okay. As the counsel for the GMC is not present, matters can adjourn to be listed after the
Item
meeting.
number 35, interim order to continue.
Sorry, no, it's already fixed on 5. I'm only passing the order in the IA. Earlier, there must have been an interim order. Yes, GMC has come. What is this, GMC?
They claim that they have seized something.
Huh?
What is that? Bicycle. Item number 30. Sure.
What matter? Who filed the IA?
In item 34, the counsel for the 5th is not there. 34. 34, I am not appealing.
Who are you?
I am item number 35.
What is 35?
35 malady is also related to that electric motors, rickshaws, rickshaw pullers, the electric machines. For they have passed an impugn order that they will seize all these machines because these are not safety on the road. So, but we have placed all the documents that there is no such accident and everything was there.
How can the GMC do that?
Now, GMC
As regards what meters?
that nowadays the rickshaws ply with that electric DC voltage, battery operated rickshaw. They
Ah.
fly with above 10 kilometers.
Huh?
The speed is above 10 kilometers. So that motor vehicle act will apply. So there is an interim order. They are in deep
But
box.
isn't it the motor vehicle? Who is appealing for the transport department?
I have filed my affidavit.
Transport department. Now, what is your step?
The contention is against the an impugned order that has been passed by the GMC, which has banned the use of the vehicle in the city government.
What do you say?
But we have not passed that order, nor we have.
You only have the power.
There's been no decision taken on that regard.
by the department.
Can you have the power?
Yes, then the speed is, when my affidavit is that there is an act of the motor vehicle act, my lord, that the particular ISO had to pass all the tests. That has not been done. And
By them.
yes, transport department take that,
So have you taken up with the transport department?
that transport department had to file an affidavit.
Understood, but why the transport department? It is the duty of the transport department to do. And madam, you are appearing for the central government? Is the central government a party?
Central government is not a party. Whatever.
What type of petition both of you have filed without making the central government a party? Because the central government is the main issue. Because they are the person who regulates the rules.
The impugn order was passed by the GMC authority. That is why.
Understood. So who are the actual authorities who
The
does?
transport authority.
It is the central government.
Central government.
They do it under those rules,
Rule.
which
And
is
my
being
lord, the-
followed by the DTO.
Yes.
What business does the GMC has?
And my lord, in that, our writ petition item 35, the principal secretary government of India, they have stated that it's not required, that particular act of central motor vehicles is not required for this seconds. It was sent to all the all the states and the union territories. That is at page 38 in our writ petition. Because they said, rickshaws are there, but they fit it, after rickshaws are purchased, they fit it, they're retrofitting that motor. And that speed increases beyond. We are not retrofitting.
Or they are increasing the speed.
Speed of beyond 10 kilometers. Then the transport.
Why the
department-
transport is not doing anything?
As per our information, these vehicles are not registered with the transport department. And if there is any other action that has to be taken, it has to be taken by the police, the traffic police.
It is not required to be registered.
Dipahana is not a type of vehicle that is registered.
So are you saying that e-rickshaws are not to be registered?
Madam, these are not e-rickshaws, madam. These are rickshaws, three-wheeler rickshaws, which are retrofitted. It's the ordinary rickshaw. Ordinary rickshaw. Puller, with the rickshaw puller. It's a rickshaw puller, but they fit a retrofitting, they fit a motor. Then the speed increases. What we'll see now, the rickshaws, they do pedal. They with the speed, they pull their switch, it goes on. It increases the speed of more than 10 kilometers, so transport department won't come. It is not the e-rickshaw. E-rickshaw is electric. This is totally different. This is another type of rickshaw.
I have not seen these type of rickshaws.
And the government of Assam has drafted a cabinet memorandum for amendment. That is also, we have annexed at page 40. For special registration.
So nowadays you have put a machine.
Machine that DC operated, battery operated charger machine.
In that rickshaw, which has a
No, no.
small.
We are Deep Bahan. We are Deep Bahan. This has been formulated by the IIT Guwahati. Low flooding, that is, my lord, we have annexed all those documents.
Show me a photograph of that.
Lordship takes up petition number 1648 and page number 43 is the photograph.
This is a very interesting.
43, 44. 1648 is not me, madam. 1648.
Where is the photograph? Oh, this
Page number
one.
43. This is the rickshaw.
Ah, these are the same.
Yes, Lordship.
With the tires and all.
45, Lordship, that is the motor. Backside. A retrofitted motor comes up in 45.
Let's see the definition of the Central Motor Vehicles Act. The latest Central Motor Vehicles. They have a. Yeah, for.
I'm giving the central motor vehicles.
No,
rules.
we have the book. Has the transport department filed any affidavit?
No.
You file your affidavit, but have a look at the transport. Iko nohoy muta hobo ifale to. Ikini mano to boy kinta agot. This is the latest one.
Hello. Rule 126. I think it is there. E-rickshaw is at page 2, your lordship.
Means a special purpose battery
Battery
operated
Vehicle.
having 3 wheels
Wheels.
and intended to provide last mile connectivity for transport of passengers for hire
Or
is
reward.
constructed or adopted to carry more than 4 passengers excluding the
That is e-rickshaw.
provided such vehicle is constructed.
And at page U, my lord, your lordship will find battery operated vehicle. U. STU.
Vehicle adopted for use upon roads and powered so now, you will be a motor vehicle.
Not motor vehicle.
Yes. Let us see what is the meaning of motor vehicle. Motor vehicle.
U. Motor vehicle. Battery operated. Battery operated.
Now, when you see the proviso, provided that a two-wheel battery operated vehicle shall not be deemed to be a motor vehicle, meaning thereby, if it is a three-wheel battery operated, it will be a motor vehicle. And if it is motor vehicle, are they not required to register it?
My lord, and they have withdrawn my motor, those particular battery operated machines, because the reasons shown in the impugn order is not safety.
Obviously, it is not safety.
But my lord,
With,
we have
with those thin tires, you cannot have like this. It is not safe. Either have bigger tires and all. With a high speed out
and
there,
your
you
lordship
cannot
will
do that.
find, we have
Anyway, the transport department is directed to file the affidavit on or before. Next date is fixed on 5/2.
Right.
We directed to file the affidavit on or before 31/2025. It's the matter. Again on 5/2/2025, lease these matters again on 5/2/2025. Interim order postulate shall continue till then.
I have filed an IM.
For what?
Part of the interim order, my lord.
I have 34.
For vacating.
They are prohibiting me not from flying, my lord. Which are by the GMC authorities, my lord.
They're prohibiting. There's an interim order.
There is the interim order regarding big bahans. Big bahan.
Every Bahan is a
Big bahan is a different thing, and these are retrofitted, and no seizure lease has been given in the next interview.
Well, we'll have it on 5/2. You are already a party.
Yes, yes.
You are the petitioner
I am the writ petitioner, my lord. By
in 34.
34 minutes.
34, you are a petitioner. Okay, we'll consider with on that day.
Four rickshaw pullers are being restrained, my lord.
First of all, stop that using that machine out there because this is a very dangerous.